Chapter 13 Bankruptcy. This video includes all the paperwork, the procedure, and documents that you will need to file a Chapter 13 bankruptcy. It also includes the different costs to file a Chapter 13 bankruptcy.
I do not show how to fill out the forms because most of them are easy and self-explanatory. However, the last form, the most important form, Form 113, Chapter 13 Plan, is where people have problems. When you calculate how much you will have to pay each month, your calculations have to take into account how much you will pay the trustee. The trustee gets paid from 4% to 15% of the total amount you pay into your case. So, if the total amount you will pay in your plan is $36,000 over 5 years, and the trustee charges 10%, then you have to pay the trustee $3,600, or $60 a month. If you use a lawyer to file your Chapter 13 bankruptcy, and he charges you $4,000, with a $400 upfront cost, thus, leaving you $3,600 left to pay, then your plan will include monthly payments to the lawyer of $60 a month. So, before you even start calculating what you will pay to your creditors, you know you will have to pay the trustee $60 a month, the lawyer $60 a month, for a total of $120 a month. After you complete your repayment plan, you will have to start making payments within 30 days of filing the plan with the court. It may take the court 3 to 6 months to approve or deny your plan, but you still have to start making the payments within 30 days. The amount you pay in your plan will be equal to the amount of disposable income you have. Thus, after you do the calculations and you find that you have $300 a month of disposable income, then over 5 years, you will pay $300 times 60 months, which equals $18,000. When calculating your disposable income, the judge might require all of your disposable income to go to paying your creditors, leaving you with no buffer for emergencies. Emergencies such as a car breaking down or taking off from work because of a sick child. Many fail at a Chapter 13 bankruptcy. Many will make 1 to 3 years of payments, then something happens, and they fall behind on their payments. When this happens, all the payments they made over the past 1 to 3 years mean nothing. Plus, every state can have its own rules. Like the state of Ohio have their own rules. Chapter 13 will not get rid of most of your debts. It is designed to get you caught up on paying your debts. Please watch this whole video to the end before you file. Before you pay the court costs and court fees. Plus, you have to take a credit counseling class before filing bankruptcy, which costs between $25 and $50. Plus, after you file your paperwork, you have to take a personal financial management class which costs between $25 and $50. If you want to know how to file bankruptcy on your student loans, then go to our website.
Please hit subscribe or like. Thank you.
Chapter 13 Bankruptcy. What you are going to need. You're going to need a copy of your credit report, last 60 days of pay stubs, and current and last 2 years of tax returns. You can get a free copy of your tax returns from the IRS. Once a year, you can get a free copy of your credit report from the following places. Over the internet, www.annualcreditreport.com. By phone, 1-877-322-8228. When you call to get your credit report, you will go through a verification process, and then they will mail the report to you. By mail, Annual Credit Report Request Service, P.O. Box 105281, Atlanta, Georgia 30348 5281. Forms List. The first part of a Chapter 13 is kinda simple. However, it becomes complicated when you start putting together your Chapter 13 repayment plan. The following are the forms you will need for a Chapter 13 bankruptcy. All bankruptcy courts will not require all of the following forms. Plus, there might be additional forms that your local bankruptcy court might require, which are not listed here. You can download all of the forms at www.uscourts.gov. Certification of notice to individual consumer debitor or debitors. Notice to individual consumer debitor. Declaration about an individual debitor's schedules. Form 101. Voluntary petition for individuals filing for bankruptcy. Form 121. Statement of Social Security number. Form 122C-1, Chapter 13, Statement of your current monthly income and calculation of commitment period. Form 122C-2, Chapter 13, Calculation of your disposable income. Schedule A and B, Property. Schedule C, the property you claim as exempt. One of the most important parts of any bankruptcy are the exemptions. Exemptions are important because they will allow you to keep certain items, such as a car, tools for work, money in your checking or savings account, etc. Schedule D, creditors who have claims secured by property. Schedule E/F, creditors who have unsecured claims. Schedule G, schedule of executory contracts and unexpired leases. Statement of financial affairs for individuals filing for bankruptcy. Schedule I, current income of individual debtor or debtors. Schedule J, current expenditures of individual debtor. Chapter 13, Debtors' certifications regarding domestic support obligations and Section 522Q. Form 101, Credit Counseling Requirement and Certificate of Credit Counseling. This is part of the voluntary petition form. Exhibit D, Compliance with Credit Counseling Form. Certificate of Credit Counseling. Debitor's certification of completion of post-petition instructional course concerning personal financial management. Personal Financial Management Certificate. Form 113, Chapter 13, Plan. We are not going to go over any of the forms. Most of these forms are simple to understand. The last form, Form 113, Chapter 13, Plan, is where it all becomes complicated. When you file your paperwork, you must have completed the required credit counseling class and personal financial management class, and file your certificates of completion. You can find approved classes at www.uscourts.gov/services-forward/bankruptcy/credit-counseling-and-education-courses. Within 30 days after filing the paperwork, even if the plan has not yet been approved by the court, you must begin making payments to the trustee. You can find the trustee office at www.uscourts.gov. In addition to all these forms, every state and counties within a state can have different procedures when it comes to filing a Chapter 13 bankruptcy. For example, in the state of Ohio for Canton, Akron, and Cleveland, one has to file a summons and a complaint to avoid a lien. Plus, you do not mail the court the payments. They take it out of your paychecks. However, when you fill out Forms 122C-1, Chapter 13, Statement of your current monthly income and calculations of commitment period, and Form 122C-2, Chapter 13, Calculation of your disposable income, your current income does not include Social Security or Social Security disability or any kind of disability payments. Please see Federal Law 11 U.S.C. Section 101, 10A-B. If on these forms your disposable income is less than $124 a month, then you should be able to file a Chapter 7 bankruptcy. For a Chapter 7, you will still have to fill out the paperwork and go through the calculations to prove your income is below $124. If your disposable income is more than this, then you will have to go through the calculations to see if you can file a Chapter 7 bankruptcy. You have to do the calculations. The calculations will include, but not limited to, if you are married or single, the number of kids you have, how much it will cost to make your house safe to live in, car repairs, rent, religious contributions. Your living expenses have to be reasonable, such as you cannot be living in an apartment in the upper part of town, where your income says that you should be living in an apartment in the lower part of town. Important: if most of your income is from Social Security or disability payments, then you probably will not be able to file a Chapter 13 bankruptcy you will have to file a Chapter 7 bankruptcy. Current monthly income for a Chapter 13 bankruptcy does not include income from Social Security or disability payments. Consequently, your income to make monthly payments for a Chapter 13 bankruptcy might be zero. Please see 11 U.S.C. Section 101, 10a-B. After you file these forms with the clerk's office, you will get a case number. Then by mail, the clerk will send you a letter telling you where to send the payments. If you do not get a letter in 2 weeks, call the clerk's office and check. Next, you will meet with the trustee assigned to your case. Before you meet with the trustee, mail him copies of your tax returns or tax transcripts, pay stubs, and Form 121, Statement of Social Security Number. At this meeting, the trustee will go over your plan and tell you if you need to make any changes. Next, you will see a judge, and she will either approve the plan or tell you to make changes. At the end of 3 to 5 years, you will get an order from the court telling you that you have completed the plan. You are now out of delinquency, and the debts that were supposed to be discharged in the plan have been discharged. More like paid off. Cost of Chapter 13 bankruptcy. If you do it yourself, it costs about $310 to file a Chapter 13 bankruptcy. However, every few years they increase the cost. After you complete your repayment plans, you will have to start making payments within 30 days of filing the plan with the court. It may take the court 3 to 6 months to approve or deny your plan, but you have to start making the payments within 30 days. In addition, the bankruptcy trustee that is assigned to your case is paid by you. He gets paid from 4% to 15% of the total amount you pay into your case. So if the total amount you will pay in your plan is $36,000 over 5 years, and the trustee charges 10%, then you have to pay the trustee $3,600 or $60 a month. If you use a lawyer to file your Chapter 13 bankruptcy, and he charges you $4,000 with the $400 upfront cost, thus leaving you $3,600 left to pay, then your plan will include monthly payments to him of $60 a month. So, before you even start calculating what you will pay to your creditors, you know you will have to pay the trustees $60 a month, the lawyer $60 a month, for a total of $120 a month. The amount you pay in your plan will be equal to the amount of disposable income you have. Thus, after you do the calculations and you find that you have $300 a month of disposable income, then over 5 years, you will pay $300 times 60 months, which equals $18,000. Plus, you will have to take a credit counseling class before you file bankruptcy, which costs between $25 and $50. Plus, after you file your paperwork, you have to take a personal financial management class, which costs between $25 and $50. If you cannot afford the $25 to $50 fee, these companies must provide it for free. Certain requirements will apply. Overview on Chapter 13 Bankruptcy. Chapter 13 is a voluntary repayment plan. The repayment plan usually lasts for 3 to 5 years and is designed to pay off all or most of the debts. Basically, all a Chapter 13 bankruptcy does is allow you to get caught up on past due debts. For example, if you are behind on your mortgage by $6,000, then a Chapter 13 bankruptcy will allow you to pay it over 5 years, or $100 per month. $6,000 divided by 60 months. Consequently, you just added an extra $100 per month to your mortgage payments. If you own anything of value, you will have to sell it or pay the value of it to the court. For example, if you own a car worth $6,000, free and clear, completely paid off, if you want to keep your car, you will have to sell it or pay the court $6,000 over 5 years or $100 per month. The court will then use the money to pay your creditors. Another example. When they repossessed your car, you still owed $10,000. Then, they sold your car for $4,000. Thus, you still owe $6,000. In a Chapter 13, you still have to pay off the $6,000. If you are going through a foreclosure or are in a default regarding your student loans, a Chapter 13 bankruptcy may stop the foreclosure and allows you to become current on these loans. However, it does not discharge or pay off these kinds of loans. For student loans, you will still owe the full amount. In order to get rid of student loans, you have to go through an additional procedure. No matter what state you live in, we strongly suggest that you talk to a bankruptcy lawyer regarding a mortgage or a foreclosure before you file. A mortgage or a foreclosure can be complicated, and to make sure your rights are protected, talk to a bankruptcy lawyer. Do not make the mistake of talking to just any lawyer. A lawyer that does not specialize in bankruptcy will probably not know all the ins and outs of bankruptcy, and will probably do more harm than good. In general, the steps for a Chapter 13 bankruptcy are: 1. Fill out all the required forms, the Chapter 13 bankruptcy plan, and submit them to the bankruptcy clerk's office and receive a case number from the clerk. 2. Current and the past 2 years of tax returns or tax transcripts and 60 days of pay stubs. You can find the trustee office at www.uscourts.gov. You can get a free copy of your past tax returns from the IRS. Very important. Before you submit the form statement about your Social Security numbers, taxes, or pay stubs, ask the bankruptcy clerk's office if you should mail these to the trustee or file them with the clerk. Every state has a different procedure when it comes to this information. 3. Within 30 days of filing the paperwork, even if the plan has not yet been approved by the court, you must begin making payments to the trustee. You can find the trustee office at www.uscourts.gov. 4. Then you meet with the bankruptcy trustee to work out if the plan is feasible. 5. Then you go in front of a judge, and the judge approves the plan. However, it can take 3 to 6 months for your plan to be approved. Remember, within 30 days of filing the paperwork, you have to begin making payments by mailing the money to the trustee. So, have all the paperwork completed, and know for sure you can make the payments before you file the paperwork. The court cannot force you into a Chapter 13 bankruptcy. They can only not approve the plan. The problem is that many cannot complete a Chapter 13 plan and end up filing for a Chapter 7 bankruptcy. When this happens, you will have to pay an additional $335. Under a Chapter 13, you can cure a debt. This means that your plan will provide you a way of getting out of delinquency or making the debt current. However, this will probably increase your monthly payment amount. If you want to cure the debt, you must make protection payments before the plan is approved by a judge. The protection payments must be equal to the amount you would pay under the plan. However, this still may not stop the foreclosure or repossession of the car, and you will not get the money back if they do a foreclosure or repossess your car. If you do want to make protection payments, file with the court Form B1130, Motion, Notice and Order for Adequate Protection Payments, an opportunity to object. Then have the judge approve the protection payments before you make any payments.
Please hit subscribe or like. Thank you.